Let's start chapter number 3, concept of the constitution. Meaning, the term constitution is derived from the Latin word constituere, which means to establish or to set up. In the present sense, the term constitution refers to a set of principles which specify the organization and working of government and relationship between the government and people in terms of their rights and duties. The constitution is variously described as the fundamental law of land, supreme law of the state, basic law of the country, instrument of the government, rule of the state, basic structure of the polity, grounded grounded norm of a country, and so on. Political scientists and constitutional experts have defined the constitution in the following way. Gilchrist: the constitution consists of the body of rules or laws which determine the organization of government, the distribution of power to the various organs of government, and general principle on which these powers are to be exercised. Gattel: the fundamental principles that determine the form of state are called its constitution. These include the method of which the state is organized and distribution of its sovereign power among the various organs of the government, the scope and the manner of exercise of governmental function, and the relation of the government to the people over whom its authority is exercised. Wearer: the person's name. The constitution describes the whole system of government of a country, the collection of rules which establish and regulate or govern the government. Wade and Phillips: a constitution is document having a special legal sanctity which set out the framework and principal function of organ of the government of the state and declare the principle governing the operation of these organ function. The constitutional scholar Elliot Bloomer have very well identified the function or the purpose of the constitution. His list is comprehensive and includes the following points. First point: it can declare and define the boundaries of the political community. Second, it can declare and define the nature and authorities of political community. Third, it can express the identity and value of a national community. Fourth, it can declare and define the right and duties of a citizen. Fifth, it can establish and regulate the political institution of the community. Sixth, it can divide or shape power between different layer of government or sub-state communities. Seventh, it can declare the official religious identity of the state and demarcate relationship between scared and secular authorities. Eighth, it can commit the state to particular social, economic, or developmental goal. Qualities: there are some qualities or characteristics of good constitution. There are explained below. Brevity: a constitution should be precise and should not be contain unwanted provision. A lengthy constitution with too many details creates the fusion in the interpretation of its clause. Clarity: a constitution should specify its provision in clear terms. A complicated language would reduce the degree of its understanding. Definiteness: a constitution should be contain a definite meaning for a provision. The ambiguous and difficult meaning would increase the discretion of the judges in their interpretation. Comprehensiveness: A constitution should be comprehensive in laying down the power of the government as well as the right and duties of the citizens. This would reduce the scope of controversies and litigations. Sus- Suitability. A constitution should reflect the need and aspiration of a people. It must be suitable to the historical, socio-cultural, economical, political condition of a nation. Stability. Sixth, stability. A constitution should facilitate political stability and should not allow easy tampering. This would strengthen the obedience of the citizen to the constitution. Seventh, adaptability. A constitution should be dynamic and not static. It should be able to adapt itself to changing situation and requirement. It should be living document. Classification. The constitution are classified into the following type: evolve and enact. First classification. First, evolve and enacted. On the basis of evolution, constitution are classified into evolved and enacted constitution. An evolved constitution is the outcome of slow and gradual evolutionary process. Its provisions are contained in the form of convention, practice, principle, and judicial decisions. It is also known as the cumulative constitution, and the British constitution is a good example in this regard. An enacted constitution, on the other hand, is deliberately made by the Constituent Assembly or Constitutional Council or promulgated by the king or parliament. Its provisions are contained in form of a book or a document or a series of documents. It is also known as the conventional constitution, and the American and Indian constitution are the good example in this regard. Second, written and unwritten. On the basis of incorporation of provision, the constitution are classified into a written or unwritten constitution. A written constitution is one in which the provisions are incorporated in form of book or a document or a series of documents. It consensually formulated and adopted by the body known as a Constituent Assembly or the Constituent Con- Convention, or by any other name. It is also known as a documentary constitution or a codified constitution. The constitution of the USA, Canada, Japan, France, India are some of the good example in this regard. A unwritten constitution. A unwritten constitution, on the other hand, is one in which the most of the provisions are not incorporated in form of a book or document or a series of documents. It is found in the form of convention, practice, principle, charter, statutes, and judicial decision. It is the product of historical evolution and not deliberately formulated by a body. It is also known as a non-documentary constitution or an uncodified constitution, and the constitution of UK, New Zealand, Israel are the good example in this regard. The distinction between the written constitution and unwritten constitution is more or less the same as it is between an evolved constitution and enacted constitution. Third, rigid and flexible. Based on the method of amendment, the constitutions are classified into the rigid and flexible constitution. The classification was given by the Lord James Baker. The rigid constitution is one which cannot be amended in the same manner as the ordinary laws. It requires a special procedure for its amendment. In other word, it make a distinction between the constitutional law and other ordinary law. A flexible constitution, on the other hand, it is is one which can be amended in the same manner as ordinary laws. It does not require a special procedure for its amendment. In other words, it does not make a distinction between constitutional law and the ordinary law. A flexible constitution is also known as an elastic constitution, and the constitutions of the UK, New Zealand are the good example in this regard. A rigid constitution is also known as the inelastic constitution, and the constitution of USA, Australia, Switzerland, and some example in this regard. The constitution of India is neither rigid nor flexible, but synthesis of both. Fourth, federal and unity. Based on the nature of the relationship between the national government and the regional governments, the constitutions are classified into the federal and unitary constitutions. A federal constitution is one which provides for the division of power between the national government and the regional governments. It enables them to operate in their respective jurisdiction independently. A unitary constitution, on the other hand, is one which provides for a concentration of power in the hand of the national government. It makes the regional government to operate as the subordinate agency of the national government and exercise only such power which may be delegated to them by the national government. Federal constitution is a prevalent in the USA, Switzerland, Australia, Canada, Russia, Brazil, and some other states. Unitary constitution is prevalent in UK, France, Japan, China, Italy, Norway, and other states. The Constitution of India contains both federal provision as well as a unitary provisions. Hence, it is described as a quasi-federal by the KC, where fifth procedural and perspective prescriptive procedural and prescriptive. According to the constitutional scholar Allard Bloomer, two broad constitutional archetypes can be identified: the procedural and the prescriptives. The difference between these two types of constitution related to the nature and the purpose of the document itself. A procedural constitution define the legal and political structure of the public institution and set out the legal limits on the government power to protect the democratic process and the fundamental human rights. In addition to describing how the government function, a prescriptive constitution assume start or attempt to impose laws, a broad consensus on common societal goal that public authorities must strive to achieve. Next topic, constitutionalism and constitutional government. Meaning, the concept of constitution and constitutionalism are closely related to each other, but there are the few differences between them. Like, first, a country may have the constitution but not necessarily constitutionalism. For example, a country with a dictatorship where the dictator's word is law and be said to have a constitution but not a constitutionalism. Second, constitutionalism recognizes the need for the government with a power but at the same time insist that limitations should be placed on the same power. Unlimited power may lead to an authoritarian, obsessive government which jeopardizes the freedom of people. Only when the constitution of a country imposes limitation upon a governmental power does a country have not only a constitution but also constitutionalism. Third, the concept of constitutionalism is that of a polity governed by the under a constitution that or audience ordinance essentially limited government and rule of law as opposed to the arbitrary despotic authoritarian or a to, totally totally totalitarian rules. Constitutional government should necessarily be democratic government. Arbitrary power in the hand of any individual or a institution, even if conferred by the constitutional document. In the negotiation of the concept of constitutionalism. Fourth, constitutionalism desires a political order in which the power of the government are limited. It is another name for the concept of limited, and for this reason, a civilized government, the real justification of the constitution, find place in having a limited government and of requiring those who govern to the conform laws and rules. Definition: the concept of constitutionalism and constitutional government have been defined in the following way. Frederick Constitutionalism provides a system of effective restraints upon the governmental action. It is a body of rule ensuring fair play, thus rendering the government responsible. Ruke Constitutionalism means essentially limited government. It is a antithesis of the government by the unrestrained will be of rulers, regardless of the actual form of the effectiveness or restraints. It assumes limitation on government as opposed to arbitrary government, where constitutional, the name I am not able to pronounce perfectly, WHERER, where constitutional government means something more than the government according to the terms of constitution. It means government according to the rule as opposed to the arbitrary government. It means government limited by the terms of constitution, not government limited only by the desires and capacities of these who exercise power. ये बीमा, a form of government can only be classified as a constitutional when the rulers are subject to body of rulers and principles which limits the exercise of their power. Constitutional government is a antithesis of arbitrary rules. Third, elements. The constitutional scholar Louis Hankin identify 8 element feature or a principle of constitutionalism. There are mentioned below. First, popular sovereignty. Second, rule of law. Third, democratic government, responsible and accountable government. Fourth, separation of power, check and balances. Fifth, an independent judiciary. Sixth, civilian control of military. Seventh, police governed by law and judicial control. Eighth, respect of for individual rights. So this is the end of chapter 3. Thank you.